Muted.
All right, Ms. Kruger.
Yes, Judge.
So will several of them sit together to watch one? No.
I need to leave the meeting and then sign in on my other computer. I'm still being switched over to my personal laptop. And I'm going to make you the host, and then I'll sign back in on my other computer, return the host duties to me when I do that.
Okay.
Oh, actually, there's Lori. She just signed in. I will.
Okay.
Thank you.
You're welcome.
Do you need me, Judge?
Just make me the co-host, please.
Yes,
Actually,
sir.
wait till I come back because I've got to take off.
Yes, sir.
if it's me.
All right, ladies and gentlemen, I have about 9 o'clock. I'm going to go ahead and call the civil docket. I know there's a huge criminal docket this morning. And it looks like the two folks from the probation office who were online a minute ago figured out that they're probably supposed to be in Judge Ellison's court and have taken off. So never mind. Okay.
Yes, Judge, I noticed that too, and I called them and told them that they needed to get onto the other Zoom link.
Okay. All right. So we'll ask for announcements from the attorneys. Anyone who's present who either doesn't have an attorney or your attorney doesn't answer for you, please let me know you're here. Apart from that, please keep your electronic devices muted unless I specifically ask you to say something. Matter of the marriage of Bridget and Michael Redfern.
Sir, this is Jim Cramp. I'm the attorney for Bridget Redfern, and we have an attorney ad litem for Michael Redfern because he is a transient person and was served by citation by publication. She should be here, but I'm not seeing her name in the chat.
All right.
If I may, Lisa Voigt did call in. She's going to be 30 minutes late coming into the Zoom hearing.
Oh, okay.
I'm sure
sir.
she has stuff on Judge Ellison's criminal docket. That's massive.
All right, sir. Well, we'll only need, I put 45 minutes on the motion, or rather the setting. It should take much less than that. This is not a divorce. They got divorced November of 2019, and 3 of her awards were bungled in the decree. So I have orders for clarification and then for enforcement of the property division so that she can get her federal employee retirement system, former spouse annuity, thrift savings plan payout, and then also a judgment on some Randolph Brook bank accounts so I can get a writ of garnishment and get her paid.
Okay, sir. All right. How long to hear this then?
Sir, it's probably 20-25 minutes, depends on how many questions you have. Judge Ellison heard the divorce when we came back and started this case and got Attorney Voigt appointed. Judge Ellison also heard that, but this is our first time in front of you, so I'll give you as much background as you want, but other than that, we can move pretty fast, real fast.
Okay, I'll mark you conferring in 25 minutes.
Thank you,
The
sir.
matter of the marriage of Roy and Dina Mazik.
That case has been dropped, Judge.
Okay, yeah, hold on a second. In the interest of the Torres children, Samuel, Matthew, and Jacob.
Andres Diaz, Your Honor, on behalf of Samuel Torres, probably about an hour, Your Honor. And I have to announce I've got a plea in Judge Ellison's court. And I've got about 5 other criminal cases in Judge Ellison's court I got to announce.
Okay, I'll let you announce there, and when you come back, I'm going to ask you and Ms. Torres to confer in a breakout room before we get started.
Okay, Your Honor.
All right, Ms. Torres, did you catch that? There are both judges in this county have Zoom dockets going, and Mr. Cedillos has an answer in both dockets. So he's going to leave for a while, but he will return.
Okay, thank you.
The matter of the marriage of Jared Rashid and Devi Boone.
Your Honor, Paul O'Finen for Devi Boone, who is the original petitioner and responded in the bill of review.
Morgan Glennie, present for the petitioner. I think it's going to be about an hour.
I would say at least an hour, Judge, maybe more.
Okay, and is Jean Brown involved in the case?
Not that I'm aware of, Judge. I'm not
Okay,
even sure who that is.
she's on the docket.
Your Honor, Miss Glennie is my associate attorney.
Oh, okay, all right. And I need to tell y'all, I have a extensive saga with computer issues, and I am reduced to having dug my old personal laptop out from underneath the bed because both my state laptop and my personal laptop are kaput. And it does not have a jack where I can run 2 monitors, so I can only see one thing at a time. Right now I'm looking at the docket on Adobe. So I will mark y'all 60 minutes, and it probably won't be terribly long before we get started on that.
Thank you, Judge.
Your Honor.
All right. All right. In the matter of the marriage of Skylar and Joey Bonavente.
Yes, Your Honor. I have hired an attorney, but he's out of town right now because his wife has cancer and I can't get in touch with him until Friday.
Okay. What are we set for today?
Divorce and custody and attorney general.
Okay. So what are you asking to do?
Reset, please.
Okay. And Lauren Reed is your attorney?
No, Ralph. I forget his last name. I'm sorry.
Lauren Reed is with the Attorney General's office, Judge.
Oh, okay.
She was sent an invite today as well.
Okay. All right. And Mr. Bonavente, are you opposing a continuance to another date?
Yes, sir.
All right. I don't actually know what we're set for today because it says awaiting genetic test results. That doesn't actually say it's set for trial or anything else. So I am going to mark this case reset on request. Anyone can contact the coordinator's office, court administrator's office, and get this set for trial on the merits if it's appropriate to do so. All right, in the matter of the marriage of Ryan and Lindsay Smith.
Your Honor,
Your Honor.
this is Aida Rojas Moore. We are present on that. Rachel Reuter is on Zoom as well. We have an agreement. We just need to read into the record.
Your Honor, we do. I do not think my client is online yet, though. So if I could just have a few minutes to try and find my client and have her sign on to the Zoom.
Definitely.
Okay, all right. Anyone else told to be here today? Your case was not called. All right, Mr. Smith, what? You answered?
He's on the case you just called, Judge.
All right, so I'm going to mute him. Anyone else told to be here today? Your case was not called. Okay. All right, I am going to ask the attorneys to confer and Ms. Riley to open some breakout rooms and let them do that. If you can't settle this, just get it narrowed down to whatever we're having hearings about. I'm going to go and look at my email in just a few moments, and then I will return and we will start. Well, if Lindsay Smith is here, we'll start with that. If
She's not here yet, Your Honor.
okay, when I come back, and if Lisa Voigt's present, we'll start with that, and if not, then we will start on the 60-minute case. I'll ask the attorneys in that case if there are documents that I need to look at. if you would post them to me in chat in a PDF format, I will look at them and be ready. And let's see, I see Elisa Redfern is just signed in.
That's my client, Your Honor.
Okay.
And Judge, I believe Lindsay Smith came on the last case.
Okay, well, let's go ahead and take care of that then before I look at the email. The matter of the marriage of Ryan and Lindsay Smith.
I don't see her now. There
Trying to
she is.
raise
She's on.
Reuter.
There she is. All right, hey, Lindsay.
That is my client, Your Honor. Rachel Reuter, present for Ms. Smith.
Morning.
Morning. All right, and do we need to have anyone sworn in?
I'm unable to hear anybody.
All right, we can hear you. All right. All right, I just sent Ms.
Okay,
Smith.
but I can't hear you guys. I'm not sure what to do. Let me look. Is that better?
Okay, can you hear us?
Yes.
Okay, excellent.
Sorry about that.
All right, and Ms. Reuter, do you need to have your client sworn, or she's just gonna?
Your Honor, I think both the
Bless you.
parties need to be sworn, and I think Ms. Rojas is going to read the agreement into the record. Is that correct, Ida, or do you want me to do it?
No, that is correct. I will do that.
All right, and where is Mr. Smith?
Mr. Smith, would you say something so we can see you on the screen?
He is on. I see him.
Okay.
Looks
Mr.
like
Smith, I'm asking you to
he's-
unmute and start your video.
I think he's frozen, Judge.
Okay. Well. Okay.
Okay.
I'm going to go and check my emails. I will return shortly, and hopefully we'll have all four, both parties, both attorneys on Zoom.
Thank you, Judge.
Thank you, Your Honor.
Does anybody need a breakout room?
If
Lori,
you want
this-
to put me and Miss Glenny, that would be fine, ma'am. If she wants to do it, I don't know.
Sure. And will that be Jean Brown as well?
I don't know. Jean didn't sign the pleadings. It was Miss Glenny. So if both of them want to come in, that's fine with me. It's up to them.
I would like to go in the breakout room, Your Honor. This is Jean Brown.
Okay, I'm gonna put y'all in breakout room. I'm in, this is Lori. I'm the court coordinator. I'll
Thank
get
you.
y'all into a room, okay?
Thank you, ma'am.
Thank you, Lori.
Yes,
Look,
Y'all
Lori,
want a
this
little, y'all get a little pop-up window that's gonna tell you to go into breakout room 1, okay?
Lori, this is Jim Cramp with the Redfern case. I have three orders that I e-filed yesterday. I don't know that you have them. How would I get them to the judge?
This is Paula with the district clerk's office. We do see the orders in e-file. We're just waiting for the judge to, just for the hearing, and then we'll forward it over to the judge for his signature.
Oh, got it. Thank you.
Uh-huh.
Does anybody else need a breakout room? Thank you.
Ms. Riley?
Yes.
I thought I was supposed to go into a break room with somebody, but I haven't been invited into one.
No, Mr. Cedillos, and you need to go into a breakout room, but he had to go to another court and sign in with that judge on that one. So when he
Okay,
gets back, I'll place y'all in a breakout room.
Okay, got it. So I'm just waiting then, correct?
Yes, ma'am.
Okay, thank you.
You're welcome.
Judge Wilson?
Yes.
Sir, we're still having problems with my client, Mr. Smith, his computer and phone right now. I don't know how much longer it will be. I don't want to delay your hearings.
Okay, no, I'm still just trying to answer a couple of emails and then we'll start.
Okay. Okay, sir. Thank you.
But Ryan Smith is on now.
I know he's on, but he's not able to hear or say anything right now.
Yeah,
Thank you.
Okay.
I switched.
Mr. Smith?
I can hear and see now.
But we can't see you.
You can't.
I can see him, Ida.
Me?
Really?
I see him too.
Wow, I don't.
Yeah.
Oh, there you are. He's okay. He's on a different. Okay, I'm still looking at the other one up top. I see him now. Very good. Thank you, Mr. Smith.
Yeah. No, long.
Okay, I'm back. If we're ready to go on the Smith matter.
We are, Your Honor.
And, okay, Ms. Reuter, go ahead. I mean,
Your
Ms.
Honor.
Rojas Moore, I'm sorry.
That's okay.
That is okay. I don't know if you swore them in, Your Honor.
Okay, I have not done nothing. Let me ask both the parties to raise their right hands. Do each of you solemnly swear or affirm the testimony you may give in the matter now on trial will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Yes, I do.
Okay. All right. Go ahead, ma'am.
All right. Would you please state your full name for the record, Mr. Smith?
Ryan Allen Smith.
And Mr. Smith, when you filed this petition for divorce, were you a resident of Wilson County for 90 days or more?
Yes, I was.
And were you a resident of Texas for 6 months or more?
Yes, I was.
Are you asking this court for a divorce on the grounds of insupportability?
That's correct.
And is there any possibility of reconciliation in this marriage?
No,
During the pendency of this divorce, did either you, Mr. Smith, or Mrs. Smith file for bankruptcy?
no, we did not.
Now, sir, how many children are in this marriage?
3.
And have you and Ms. Smith entered into an agreement regarding conservatorship, child support, health insurance, and possession and access?
Yes, we have.
And I'll go over those details in just a bit. Have you and Ms. Smith agreed to property division in this case?
Yes, we have.
Now, sir, regarding the children, have you and Ms. Smith agreed to be joint managing conservators of these children?
Yes, we have.
And you understand that Ms. Smith and the children will be relocating to California in May of this year. Is that correct?
Yes, I do.
And you're in agreement to that, correct?
I am in agreement.
Now, sir, have you and Ms. Smith agreed to have equal rights and duties to these children?
Yes,
And for possession, you and Ms. Smith, have you two agreed for long distance visitation with these children, and you would be responsible for 100% of all those costs
yes,
pertaining to visitation with the children, correct?
that's correct, pertaining to visitation with the children.
Have you and Ms. Smith agreed to telephone communication that includes FaceTime and Zoom while the children are in the other party's possession?
Yes, we have.
Have you and Ms. Smith also agreed to passport provision as stated in the Texas Family Law Practice Manual?
Yes, we have.
And have you all agreed that Ms. Smith will maintain possession of all these passports?
Yes, we have.
Have you and Ms. Smith also agreed to child support in the amount of $406 beginning June 1st through October 31st of 2021? Is that correct?
That's correct.
And beginning November 1st of 2021 and into the future, you have agreed to pay $1,750 per month. Is that correct?
That's correct.
Now, in the if you maintain employment prior to November 1st, 2021, you have also agreed that you will pay Ms. Smith the difference of the 406 and the 1750 directly to her. Is that correct?
That's correct.
Now, as far as medical and dental insurance, you both have agreed that prior to your employment, Ms. Smith is going to attempt to get government assistance for the benefit of these children. Is that correct?
That is correct.
Now, as far as vehicles, Mr. Smith, Ms. Smith is maintaining possession of her Nissan, and you're maintaining possession of the Dodge Ram and Chrysler 300. Is that correct?
That's correct.
And each of you will maintain everything that is in your possession presently. Is that correct?
That's correct.
Now, Mr. Smith, specifically about the property that you two have, I just want to go over this very quickly. For you, both parties, the Voya retirement will be divided 50-50. Is that correct?
That's correct.
Ms. Smith will maintain possession of the Jan Hancock IRA 100%. Is that correct?
That's correct.
And for the LPL Financial IRA, each of you will maintain possession of the $67,000 equally, 50-50. Is that correct?
That's correct.
And the remaining $50,000 will be split equally 50-50 when it matures. Is that correct?
That's correct.
For the Fidelity investments, each of you will divide that equally 50-50. Is that correct?
That's correct.
And that is a general investment, but there's another Fidelity investment, NovaCure, that will also be divided 50-50. Is that correct?
That's correct.
Now, for the Fidelity Investments Roth IRA, you are maintaining that 100%. Is that correct?
That is correct.
And the Morgan Stanley stock plan, you maintain that and will keep it 100%. Is that correct?
That is correct.
Now, for the cash accounts that you have, you will maintain possession of your Bank of America savings account 9536, correct?
Correct.
And then she will maintain possession of the Bank of America 9523. Is that correct?
That is correct.
Now, both of you will still maintain possession of the Bank of America joint checking account in which Ms. Smith will deposit $11,000 into that account and you will deposit $3,000 into that account. Is that correct?
That is correct.
And after all the bills and debts have been paid out of that account, whatever is remaining, both of you will divide 50-50. Is that correct?
That is correct.
Now, for the college savings plans, Mr. Smith, for the 3 children, you will maintain control of those plans. Is that correct?
That is correct.
But you will provide quarterly statements to Ms. Smith for all those accounts. Is that correct?
That is correct.
Now, after the youngest child has either used or not used the remaining funds of that account, both of you will divide those accounts or remaining funds 50-50. Is that correct?
That is correct.
Now, each of you will keep any life insurance policies in your possession. Is that correct?
That is correct.
As far as the home that is located at 307 Fleetwood Lane, sir, both of you have decided to put that up on the market and sell it. Is that correct?
That is correct.
And both of you will divide the proceeds equally 50-50. Is that correct?
That is correct.
Now, if the home does not sell, sir, it is your agreement that you will be responsible for all mortgage and taxes on the property pending the final sale. Is that correct?
That is correct.
Now, for taxes for the year 2021, is it agreed by you, sir, that each of you will file your own income taxes individually for the year 2021?
That is correct.
Now, as for the debts, is it your agreement that you will maintain possession of the American Express, Chase, and the Citibank credit card and pay any debts associated with those credit cards?
That is correct.
And you will keep any debt solely in your name. Is that correct? Mr. Smith?
That is correct.
Okay, you froze up just momentarily. Okay. And Your Honor, I do believe that that is the agreement of the parties. I will pass the witness at this time.
Your Honor,
Right, and I wanted to say, when y'all announced, I took your announcement for some reason to be that you had a Rule 11 agreement. That's why I didn't sign your witness, swear your witnesses in to begin with. All right, and let me just interrupt on the, well, she just went away. Okay, on the Bridget Redfern case, who is her attorney, Mr. Cramp?
Yes, sir, Jim Cramp.
Okay. I have tried to admit her from the waiting room about a dozen times. I suspect that Ms. Riley has too.
Yes.
It's not working. So I sent her a message in chat. The host or co-host can send a message to people in the waiting room. Whatever she's doing is not working. And she may have logged off and logged back on, but we're trying to admit her from the waiting room and she never makes it in. She keeps cycling back.
Yes, sir. Yes, sir. She texted me and told me the same thing. And so I gave her the phone number, and the meeting ID and the passcode, and told her if she needs to just phone in.
All right. She needs to, because I'm still hitting admit and it's still, she disappears and then she's back in the waiting room. Go ahead, Ms. Ruder.
Your Honor, I just have a couple of questions just to clarify. Mr. Smith, you understand that your wife, Lindsay Smith, will have the exclusive right to designate the children's primary residence without regard to geographic location, correct?
That is correct.
And you understand that she'll have the exclusive right to receive child support, correct?
That is correct.
And all other rights will be independent rights after you two confer with each other, correct?
That is correct.
Your Honor, I have no more questions. Mr. Smith.
No more questions, Your Honor. I will pass it to Ms. Reuter for her client.
All right, go ahead, ma'am.
Lindsay, if you can state your full name for the record.
Lindsay Sean Smith.
Lindsay, you heard the agreement as read by Ms. Rojas Moore, correct?
Yes, I did.
And are you in agreement with this final settlement for your divorce?
Yes.
Do you believe these terms are in your children's best interest?
Yes.
And do you believe this property division is fair and equitable?
Yes.
Now, Lindsay, you are not currently pregnant with another child, correct?
No.
And there were no other children born or adopted during this marriage, correct?
No.
Are you asking the court to approve this agreement and render your divorce today?
Yes.
Your Honor, I pass the witness.
We rest your honor.
All right, and has the proposed divorce decree been prepared?
No, Your Honor, we just came to an agreement pretty much last night, and we're putting all of this together. We should have it to you probably by the end of the day.
Your Honor, we have a Rule 11 agreement. I think that will be to you by the end of the day, and I think the proposed divorce will probably be closer to a month away. Isn't that correct, Ida?
That is correct. I do recall our conversation. That is correct, Your Honor. We will have that Rule 11 agreement probably within about 20, 30 minutes to you.
Okay, all right. So do we want to go ahead and get an entry date and say the first week of June, or, well, actually, I think I'm in trial court. I forget we're actually going back to doing a real court.
Your Honor, when will that happen?
The judge on the circuit, typically there's one judge on the circuit, one during jury week, and the judge on the circuit is going to resume the circuit starting May the 1st. And we're going to start resuming jury trials in the first week of June. All right, no, that's Judge Ellison's week.
June 22nd would be when you were in Wilson County, Judge.
Yeah, June 22nd or
May 12th.
I think June 22nd probably is a little bit more believable for us.
Okay, and again, that's only if you need an entry date. I mean, can't get this reduced and agree to it. If you otherwise just e-file it with everyone's signatures and I will sign off on it. All right, I find I have jurisdiction to hear this matter. The case has been on file for more than 60 days. Both sides have appeared, pardon me, with counsel and announced ready. The petitioner was a resident of Wilson County for 90 days in Texas for 6 months prior to the time the lawsuit was filed. The marriage between the parties has become undermined due to a discord or conflict of personalities, and there's no present likelihood of reconciliation. There were 3 children born during the marriage, and no other children were born, adopted, or expected. And I find the proposed orders concerning the children are in their best interest. I will approve them. I'll find that the orders concerning the division of the marital property and debts are just, fair, and equitable, and approve them. And was there a name change?
I don't know, Your Honor. Lindsay, were you planning to change your name? I apologize, I forgot.
No, ma'am.
Okay. All right. And I'll pronounce the divorce in open court today, and I will sign it as soon as the divorce decree is finished.
Thank you, Your Honor.
Thank you, Your Honor.
Wish you good luck.
Are we also doing a reset date to June 22nd, Judge?
Yes. I'll set it for entry on the 22nd.
Thank you.
Thank you.
Okay. And have we heard anything from Lisa Voigt?
Not
No,
yet,
Judge.
Judge.
No.
Friday, could you just ask Ms. Poppy, I assume she's on with Judge Ellison, if Lisa Voigt's over there?
Yes, Judge, I'll go check.
Okay. Okay. All right, and let me pull the file in the, get up here. Rashid and Boone case.
Judge, they're in the midst of calling that docket. She has 5 screens of people. She's
Okay, that's fine.
kind of busy. She can't really look right now, but
I think you
She's-
can go
she's
to
aware.
find participant and search, but that's fine.
yes, sir.
All right, on the Rashid and Boone, are both sides ready?
Yes, Your Honor, I'm ready for Mr. Boone.
Yes, I'm ready.
Okay. And do we need to have the parties signed in, sworn in?
Yes, Judge, I believe we do.
Okay. And where is Mr. Boone?
Mr. Boone is in the one that shows Gonzalez Law. He's there. He has
Okay.
somebody helping him, Judge, because his arthritis is so bad he cannot really work a mouse even. So I've got somebody there helping him. So when he needs to unmute, I will have to have somebody unmute it for him because.
All right. So let me ask Ms. Rashid or Rashid and Mr. Boone to go ahead and unmute their computers.
Judge, looks like I'm gonna have to go over there and do it for him because neither one of them seem to know how to work the mouse. I'll be right back, Judge.
Go ahead.
Okay.
Oh, see, they wasn't on there when I did that.
So once you have the mouse.
Okay. Oh, but I'm gonna do,
Click on that again.
Okay, so let me ask the parties, do each of you solemnly swear or affirm the testimony you may give in the matter now on trial will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right. And ma'am, I'm not sure how to pronounce your name. Is it Rashid? Rashid?
Rashid is correct.
Rashid, okay. And did you take the oath or not?
I did.
You did, okay. All right. And I've read over the petition for bill of review, and let me just ask the attorneys, what property, is this a dispute over the property division or just the fact the divorce was granted?
It's a dispute over the property division within the divorce.
Okay.
It is.
All go ahead, sir.
Judge, it's her motion.
Oh, I'm sorry. I'm sorry. Oh, I'm sorry. I had that backwards. All right, go ahead, Ms. Glennie.
If I could give a brief opening, Your Honor, about
Yes.
this. So this is this petition for divorce was filed back in December 22nd, 2015. At the time, the parties had been married for 33 years when the divorce was filed. A citation was requested by a private process server in April of 2016 for a St. Louis address. My client was not living in St. Louis at the time the divorce was filed. There was one attempt at service. It was unsuccessful. And the affidavit by the process server says residence address provided is currently vacant. I spoke with the neighbors, but no one had any current information on Mr. Boone. The person they were trying to serve was Ms. Rashid, not Mr. Boone. The affidavit was used for the motion for alternative service, and there was no affidavit by Mr. Boone. There was no record made at this hearing to show what due diligence, if any, Mr. Boone had done to look for Ms. Rashid. It was then posted on the courthouse door in August 2016, and my client did not file an answer or make any appearance in the case. A default divorce decree was signed in December 2016, and which Mr.
All right, ma'am,
Boone-
and one of us is breaking up. I think it may be me. Hello?
Yes, Your Honor, I can hear you. Can you hear me?
Yes, Ms. Cavazos? Were you able to catch all that?
Yes, Judge.
Okay, all right. Go ahead, ma'am.
I believe there was a default decree signed in December 2016, and Mr. Boone awarded himself the residence in Floresville and awarded himself 100% of his military retirement. At the time of the default judgment, no record was made. There was no showing what due diligence had been done. There was no certificate of last known address filed. There was no non-military affidavit. There was no attorney ad litem appointed for Ms. Rashid, and there was no statement of evidence in the record. Ms. Rashid, as I said, was not living in St. Louis, and Mr. Boone knew that. They were in contact at the time, as the evidence will show. And then we filed this original petition of bill of review on September 24th, 2020, which is within the 4-year time limit. And the claim here is the lack of proper service, which led to a due process violation for my client because the court did not have personal jurisdiction over her at the time.
All right. And did you have an opening statement, sir?
Yes, Your Honor. I would like to rebut that. Your Honor, first of all, what she has not told you is that the couple separated probably about 16 years prior to the divorce being filed, 15 or 16 years. I'm not exactly sure of the date. And when the wife, Ms. Rashid, moved out, the majority of the time she kept her address and her whereabouts secret. So he did not know where she was. He had heard that she was living in St. Louis and had an address up there. She moved around quite a bit, changed jobs, and from time to time she would answer her phone.
Right.
Most of the time
I can't hear you, sir. You broke up. I heard change jobs.
She changed jobs quite frequently. She didn't always communicate with her husband. So sometimes she did answer the phone, sometimes she did not. But she was well aware of the fact that a petition for divorce had been filed, but would not give him her address so he could get her served. So she knew that divorce was pending. She wouldn't give him an address. They tried to have her served in St. Louis or Missouri. I'm not sure the exact town in Missouri, but it's in Missouri. And that was the best last known address he had of her. Now they heard that she was living in Cypress, Texas. I guess that's near Houston. And the attorney at the time sent 2 letters with a request for a waiver of service with the petition attached. So she got 2 times the petition twice and a request for a waiver of service. No response was ever made. So there was no way to know. They can say that, well, they knew she was living there. Well, we didn't know. We assumed she was. She now admits in her bill of review, her amended bill of review, that she got 2 letters from the attorney. So she knew about the lawsuit, yet she did absolutely nothing. Now, she did not use any kind of diligence to say, oh, I've got a lawsuit filed against me. I need to answer, whatever. She knew this was going on. She knew everything, and she chose not to participate. And, just before the statute of limitations was about to expire on the bill of review, and the other thing, Judge, is that they had been in communication off and on during this period of time, and Mr. Boone advised her that he was going to have to sell the house. He didn't live there anymore anywhere. His son was living there. He couldn't afford to make the mortgage payments and keep up with the taxes because she never made any mortgage payments, never paid any of the taxes at all during the time she was gone, or even now. So he told her, I'm going to put the house up for sale, and told her that when he sold it, that he would be providing her with a share of the proceeds from the house. It was apparently at that point in time is when she filed, got a lawyer and hired and went to do the bill of review. So I'm not sure, it may be a law school exam question, but I'm not sure that she acted with due diligence and that she has to be able to prove up that there was absolutely no fault and no negligence on her part. Now, had she never received any word whatsoever, I think she might have a case. But she knew about this the whole time, and now she wants to, oh, I better do something about it now. And again, I think her time to act was 5 years ago, not in September of 2020. And I think that's what it really boils down to, Judge, is was her knowledge of the lawsuit create notice and does it create negligence on her part for not doing anything about it? And then say, well, I just would never serve properly. She didn't, her bill of review does not say I was never served, since I was not properly served. So, and the court granted the motion for a 106. And so legally in accordance with the court, she has been served. And she also now admits that she had notice of the lawsuit prior to any trial or judgment that was entered. So that's going to be the hard question to answer, Judge. Is she negligent? Because if she is, then she can't, her bill of review has to be denied. If you find that she's not negligent in any way whatsoever, then you still have to make a decision, Judge. But I would say that she was negligent because she had knowledge and chose not to act upon that knowledge. She had the actual lawsuit in her hand and didn't want to sign. She just didn't acknowledge where she was. And Mr. Boone, you know, I call that, you know, avoiding process by not being forthcoming with your address when you know people are looking for you. I don't think you can hide behind the rock and say, I never got served. I never got served when you're telling everybody, refusing to tell anybody where you are. And then you come back and say, oh yeah, well, they sent me a letter to that address, but she never acknowledged that she got it or that she really lived there. So that's why they were forced to go to the courthouse steps.
Okay, but is the lack of anything under 6.409, or let me ask you, do you agree that there were no written findings or records under 6.409 where the judge approved the diligence that was shown, and why wasn't there an ad litem appointed?
Judge, I wasn't the attorney then, so I can't speak to what happened then. I don't think anybody knows. I don't know that there wasn't a record made or not. I just don't know. Anytime I do a default hearing, I always ask for a record, and I put my proofs on the record and my attorney's fees on the record. I do all the things the Supreme Court requires me to prove up. So I can't speak for another attorney who, whatever they did, Judge. But she admits in her bill of review that she was sent not one, but 2 letters from attorney advising her there's a lawsuit going on. So she had knowledge. And that to me, Judge, means that she knew it and she didn't want anybody to know where she was and wouldn't acknowledge. I mean, that's a voiding process, Judge, with knowledge of a lawsuit. I don't think you can claim, oh, gee, I didn't know anything. I think that's the real issue here, Judge, is that she knew it and chose to remain secretive as to where she lived. So I think that creates negligence on her part, Judge.
May I respond, Your Honor?
Well, I just have, either of the attorneys looked at the law on the not making a record and not appointing an ad litem? Because Mr. O'Fine, and I had a case in LaSalle County on an equitable bill of review where the respondent was not only represented by an attorney, the attorney signed a Rule 11 agreement that said he was waiving citation. And a default judgment, post-answer default was taken, and the defendant in that default filed an equitable bill of review, and the plaintiff wanted to do a bunch of discovery and saying that it was a setup, and the new attorney for the defendant in the original case said, we don't need to do discovery, Judge. We will stipulate on the record that my client knew that the rules say that an attorney can't waive citation unless they do it with the same formalities as anyone else, meaning that it has to be done under oath. And he knew that was no good, and he allowed a default judgment to be taken against him as a matter of strategy. And I said, as a matter of equity, in that case, I wasn't going to consider the bill of review. And the fourth court said to me in polite terms, read the rules, dummy. The citation has to be waived under oath, and that didn't happen. And citation hadn't been waived. There was no service. The court had no jurisdiction to grant that judgment. So why wouldn't that be the case here?
Well, just because she didn't acknowledge, she didn't sign a waiver under oath. She didn't do any of that at all. And I think that case holds that the waiver was done, but it wasn't done properly. This wasn't done at all. She didn't acknowledge at all where she was. She was hiding. That person was not hiding, but she was hiding. She didn't keep anybody appraised of her address. And she's now admitting, oh yeah, I knew about it. I knew about this lawsuit. but didn't take any steps to go forward. Now, it's something that, you know, when you go to court and you try to get people served and they're hiding from you, it makes our system of justice work that much harder, because the people that are trying to bring notice to you are now frustrated because they can't do it. That's why we have a Rule 106 motion. We have a Rule 106 available to us, because sometimes people disappear. But in this case, this woman deliberately kept her address secret from her husband and knew about the lawsuit and could have said, oh, no, yeah, I'm here. I refuse to sign the waiver of process. You're going to have to get me served. But she just said nothing. She ignored it totally. So I think that's where her negligence is. I think she abused the system by just saying, I won't do anything. I won't let them know where I'm at, and they can't touch me. You know, a lot of people try to hide from process servers. That's why we have Rule 106s. And the
All right, well, sir, but even if you're correct, I'll let Ms. Cnty speak, but I don't see how that would be nearly as egregious as hiring an attorney to file a Rule 11 agreement with the court with the intention of deceiving the plaintiff into, the stipulated intention of deceiving the plaintiff into taking a default judgment on that basis, because you know that you're going to be able to file an equitable bill of review and get it overturned. All right, but go ahead.
I think the facts are different, Judge.
May I respond, Your Honor?
Yes, ma'am.
So the burden is not on my client to make sure proper service was done. The burden is on Mr. Bloom. And under the Texas Rules of Civil Procedure, that there needs to be an O showing what due diligence was done and how they were unable to locate the defendant. The requirements for a diligent search must be inquiries that someone who really wants to find the respondent would make, and diligence is measured by quality, not quantity. He did neither. A lack of diligence renders the service ineffective and thereby deprives the litigant of due process in the trial court of personal jurisdiction. Under Texas Family Code 6.409, the citation by publication for dissolution of marriage may be done the same way other citations by publication may be done. And if there's no children, it can be posted on the courthouse door like it was here. But if there's property accumulated during the marriage, then the court must appoint an attorney ad litem. It's a mandatory provision. And here there was no attorney ad litem appointed. There was no record, or there was no statement of evidence, which is a requirement under the Texas Family Code 6.409, as well as Texas Rules of Civil Procedure 244, which gives us the two safeguards of the statement of evidence, as mentioned in 6.409, and the appointment of an attorney to represent the suit and the party, neither of which was done here. There are two cases that are very much on point that say this is a mandatory duty of the court. And since due diligence wasn't done, a record wasn't made, an attorney ad litem wasn't appointed, I believe that all of that renders this service ineffective, and the court didn't have, there was a due process violation for my client.
Your Honor, again, what she's required to prove up is that there was no fault or negligence on her part.
Okay, but did you get that far without your client proving that she was properly cited?
Well, Judge, by virtue of the publication, if you want to call it a publication on the courthouse steps, the court says that's proper citation. And again, she has to prove up, and the law requires her to prove up that she had no fault or negligence at all. She doesn't have to prove up there's other factors in a bill of review that she doesn't have to prove up. She only has to prove up the third element, and that says she has to have sufficient evidence that there was she's essentially alleging a due process violation, but she still has to prove up that she did not receive any notice of the trial, and she must prove up that she was not in any way at fault or had no negligence in allowing the default judgment to be rendered. And by virtue of admitting that she knew about it, had notice of it, then she's going to have to prove up that act of ignoring it, knowing it was happening, was not negligence.
Okay.
The other issues are meritorious defenses, and I don't see them in her amended petition.
Okay. All right. I'll let y'all put your evidence on briefly. Go ahead, ma'am.
Your Honor, I'd call my client as a witness.
Go ahead.
Ms. Rashid, will you unmute? My paralegal's going over there to help her unmute, Your Honor.
Thank you.
Okay.
Can you state your name for the record?
Yes. My name is Gajara Rashid.
And Ms. Rashid, where were you living at the time the divorce was filed?
I was living in Cypress, Texas, I believe.
And were you in contact with Mr. Boone at the time the divorce was filed and while it was pending?
Yes.
And did he ask you where you were living?
Yes.
And so he had notice of your address in Cypress.
Yes.
Were you ever served by a process server in this case?
No.
And did other people know where you were living?
Other people?
Did your family members know where you were living at the time the divorce was filed?
Yes.
And did Mr. Boone reach out to any of them asking for your address?
Objection, Your Honor, calls for hearsay.
That's
I'll overrule the objection that I have to see what her answer is first.
Yes.
And were you given notice of the trial date in this case?
No.
And where are you currently living?
110 Shady Oaks Drive, Floresville, Texas.
And was that the house bought during the marriage?
Yes.
I'll pass the witness.
Go ahead, sir.
Thank you, Judge. Ma'am, when did you first separate from your husband?
To be correct, sir, there was never a separation.
Well, so you're saying that for the entire marriage, you've lived in the same house with your husband the entire time, is that correct?
No.
Okay, then there had to have been a separation. What was the date of your separation, ma'am?
Are you asking, sir, when did I move from the house?
Ma'am, I'm asking you, what's the date you separated from your husband?
I moved to Dallas, Texas for employment in 2003.
How long did you live in Dallas, Texas, ma'am?
I lived there a little over 10 years.
And during that 10-year period of time, did your husband live with you in that home in Dallas?
No.
And where did he live at the time?
I don't know.
Okay. So if you didn't know where he lived, how were you able to provide him notice of your address?
He called me.
And isn't it true that many times when he would call you, you would not answer the phone?
That is not true.
So every time he ever called you, you always answered?
Yes.
Never got a busy signal or anything like that?
Not to my knowledge.
Did you give him your physical address in Dallas?
Yes.
Now, you say you moved from Dallas in 2003. Where did you move to? Or excuse me, you lived there for 10 years and you moved after 10 years. Where did you move after you lived in Dallas?
Let me restate, sir. My job was in Dallas.
Objection, non-responsive, Your Honor.
All right, sir. I will overrule the objection.
My employment was in Dallas, Texas, at Dallas County Juvenile Justice Center. My residence was approximately 10 miles from there in Grand Prairie, Texas.
When you moved from Grand Prairie, Texas, where did you move to?
I moved to St. Louis, Missouri.
Okay. How long did you live in St. Louis?
From September the 1st of 2014 to August 20th of 2015.
August 20th of 2015?
Yes.
So when they tried to find you in Missouri, they knew that you had been living in Missouri at the time, correct?
Objection calls for speculation.
Counsel,
Yes, Judge.
your response?
Judge, she says that she kept everybody informed of her address at all times. So it's a reasonable question. If she advised them that she lived there, then she should know.
I'll overrule the objection.
Are you waiting on me to answer?
Yes, ma'am. Please answer.
They, I assume, meaning Mr. Boone. Yes, Mr. Boone knew I lived in St. Louis.
And when you left St. Louis, where did you move to?
I moved to Cypress, Texas.
And when did you arrive in Cypress, Texas, ma'am?
August 20th of 2015.
And how long did you live in Cypress, Texas, ma'am?
Until October 8th of 2016.
And after October 8th of 2016, where did you move then?
I moved to Tomball, Texas.
And when did you receive the first letter from Mr. Boone's attorney?
I don't know.
Do you know what year it was?
The letters had been forwarded because the initial address was St. Louis, Missouri. I was living with my niece and nephew in Cypress. The letters did not come directly to me. They came for me.
And again, ma'am, when did you receive the first letter from the attorney?
I don't know at what point my niece and nephew handed those letters to me.
Do you remember what year it was?
Objection asked and answered.
She never answered the year, Judge.
Overruled.
(2016).
Okay. And you received both of the letters at the same time or at different times?
I recall at different times.
Okay. And you recall that the letter contained the petition for divorce and a waiver of service, correct?
The letter did ask me if I wanted to waiver my right for service.
I understand that, ma'am, but it also contained the actual petition for divorce, did it not?
Yes, and inclusive was that I want to waiver my right to be served.
I understand that, ma'am, but both letters contained the same petition and the same request for waiver, correct?
They did.
Okay, so at that time, you knew that there was a divorce pending in the court in Wilson County, correct?
No.
Well, you did you read the petition for divorce, ma'am?
I read the letters, but Mr. Boone from time to time would say things and not follow through on them.
Well, ma'am, I'm not asking about what he said. I'm asking you, did you read the petition for divorce when you received it?
I did.
Okay, so you had knowledge that there was a divorce pending in Wilson County, correct?
I also had knowledge that I had a right to waiver being served.
I'm not asking about the waiver, ma'am. I'm asking about the fact that you knew you had been served with you had a petition for divorce pending in Wilson County.
Yes.
Okay. And when you got the letter, did you mail anything back or call anybody to tell them that you had received the letter?
I don't recall.
Do you recall advising anyone that you had moved from Cyprus to Tomball?
Yes.
Whom did you give your address to in Tomball?
My daughter,
Anyone else, ma'am?
my son,
Okay. So those are the only two people you advised?
those were basically the only two people who I had spoken with.
Okay. So you did not have a conversation with Mr. Boone regarding your moving to Tomball, then, is that
I
correct?
don't recall having a conversation with Mr. Boone at that particular time, but I did leave a forwarding address.
And when you left the forwarding address, was that with the postal service, ma'am?
Yes, it was, sir.
So you didn't send a forwarding address to your husband at that time, did you?
I sent it through the post office, sir.
I understand that, ma'am, but I said you did not provide your husband with a forwarding address either, did you?
I sent it to the post office.
I'll take that as a no, ma'am. Thank you. Now,
Oh, I'm sorry. I thought you were finished. Go ahead, sir.
no, ma'am. No, sir, I'm not. Ma'am, when did you move from Tomball back to Floresville?
October 2nd of 2017.
You were living in the Shady Oaks Drive home since October of 2017.
That is correct.
Who was living there at the time you moved in, ma'am?
My son was.
And after you moved in, did he stay there with you?
For a short period of time.
So he moved out at some time after that, is that right?
Yes.
Did anyone else move in with you, ma'am, after you moved there?
No.
So you've been living there alone since 2017?
My daughter lives there with me now. I didn't understand the question.
All right, well, when did your daughter move in to the Shady Oaks Drive?
My daughter has been there for a year, sir, as I recall.
So she moved in sometime in 2020?
Yes.
Now, since you've been living there, have you paid the mortgage on that home?
Objection, relevance.
All right, Mr. O'Finen.
Your Honor, it should be not relevant, will not lead to admissible evidence, and I think it will lead to admissible evidence, Your Honor.
Overrule the objection.
There is no mortgage on the home to my knowledge.
Okay, so you're not aware of,
Mortgage on the home.
that's fine, ma'am. So you're not even aware of the fact that there is a mortgage on the home, is that right?
As far as I know, there is no mortgage on the home.
Okay. And you, if you didn't know there was a mortgage, then you would not have attempted to make any payments then, correct?
There would not have been any need to make a payment, sir, without
Okay.
a mortgage.
Did you pay any of the taxes due on that property for any of the years you've lived there?
This last time, sir, or early on?
Well, you say you moved in October of 2017. So have you paid any ad valorem property taxes on that property since the date you moved in 2017?
Not since I came back, no.
Okay. Who do you think paid those taxes, ma'am?
I don't know, sir.
I have no further questions, Your Honor. Thank you.
Go ahead, ma'am.
Just a few questions, Your Honor. Who did you live with in St. Louis?
I live with my daughter.
And is your daughter's father Mr. Boone?
Yes.
And when did you find out that the divorce had been finalized?
I found out December of 2018.
But you didn't know a divorce decree had been entered until 2020, correct?
Repeat the question.
When did you find out that the divorce decree had been signed by a judge?
December of 2018, if I recall correctly.
How did you find out?
My daughter had gone to visit Mr. Boone, and in their conversation, there was something that she was able to discern. And when she returned to the home, our home there in Floresville, she found the information on the internet that he had filed.
Objection, Your Honor. This is hearsay.
I have no further questions, Your Honor.
Mr. O'Feinen?
Ma'am, you found out about the divorce finalized in 2018, but you knew about the filing of the divorce as early as 2015, correct?
Repeat the question, please.
Would the court reporter please read back the question?
Ma'am, you found out about the divorce finalized in 2018, but you knew about the filing of the divorce as early as 2015, correct?
I didn't know that he had filed for divorce.
Ma'am, you earlier admitted that you read the petition. So what did you think it was?
I read the petition asking, did I want to sign for a waiver for a divorce? I did not read a divorce decree that Mr. Boone had already filed without mine not being served.
Ma'am, we're talking about two different things here. We're talking about a decree and we're also talking about the petition. What I asked you earlier was, you read the petition for divorce. That was not a final decree. You admit you read that petition, did you not?
I read that petition.
Okay, no further questions, Your Honor.
I have no other questions.
All right, anything else from the movement?
No, Your Honor.
All right, Mr. O'Feinen?
Yes, I'd like to call Mr. Debbie Boone at this time, Judge.
All right, go ahead.
Mr. Boone, can you hear me okay?
Yes, I hear you.
Okay, Mr. Boone, you've heard your ex-wife testify that she always kept you informed of her address. Is that true?
It's not true.
What would she do to keep you informed of her address, if anything?
Nothing. The only time she ever informed me of where she was living was when she needed a new dependent ID card, and that was approximately every 4 years.
So when you separated from your wife in 2004, the only time she ever contacted you was so that she could get the paperwork completed to get a dependent's ID card. Is that correct?
That's correct. We separated. She left in 2002. Let me correct that. It wasn't 2003. It was 2002.
Okay. Now, the process server tried to serve her in Missouri. Do you recall that?
I recall that.
How did you know she had lived in Missouri?
Because we communicated when she was in Missouri that she was living with my daughter at that time
Okay, so you had an address of her living in Missouri.
in
when you-
Missouri.
Okay. Did anybody tell you, whether it was your daughter or your wife, that she had moved from Missouri back to Texas?
No,
Okay, so your lawyer somehow found an address in Cypress, Texas. Do you know how you found out about an address in Cypress, Texas?
through my lawyer. The only address I ever had on her was Dallas. She always told me, well, I'm living in Dallas.
Okay, now, when she said I was living in Dallas, she never gave you an actual street address, did she?
No,
And is that true of also of when she was living in St. Louis?
when she was living in St. Louis, she was living with my daughter. I had that address.
Oh, so you had that address.
Right.
But when she moved to Cypress, Texas, she didn't even tell you she had moved. Is that right?
No, I didn't know she was living in Cypress.
Okay, and she never
Texas.
never provided you a street address in Cypress, Texas?
No,
Did she ever provide you a street address in Tomball, Texas?
no,
Okay. Do you believe that you did everything you could to find out where she was prior to seeking the default judgment from the court?
I do.
Okay. No further questions, Your Honor.
Ms. Lenny?
Do you have Miss Rashid's phone number?
I have it written down.
And were you in contact during the time the divorce was pending?
When she was living with my daughter in St. Louis.
And are you in contact with your daughter?
Not that often, maybe once a year. She doesn't answer her phone either.
And you didn't reach out to Miss Rashid and ask for her address, correct?
Could you repeat that, please?
You didn't reach out to Miss Rashid and ask where she was living, correct?
No, I asked her once or twice where she was living. Everything she did was always secret. It started long before she left. Unless she needed an ID card, I didn't hear from her.
And you didn't reach out to your daughter and ask where she was living, where Miss Rashid was living either, correct?
Yes, I did. They wouldn't tell me, neither would my son. They would not tell me where their mother lived because of the hassles they would have of giving that information out.
And I don't have any other questions, Your Honor.
Mr. O'Finen?
Yes, Your Honor, just a couple of redirects. Mr. Boone, whenever you would try to call your wife, what was the percentage of time she would actually answer the phone when you tried to call her?
Let's say about 40% of the time.
And during the pendency of the divorce, meaning after the time the divorce was actually filed, was she receptive to your phone calls during that time?
Up until she filed, up until 3 years, I think it was, in about 4 or 5 months, she stopped answering. And I don't do texts, so she stopped answering the phone.
So she stopped answering the phone after you filed for divorce, is that correct?
Right, after she moved back to Florentsville, she stopped answering the phone.
And you didn't even know she was living there, is that right?
Well, I knew she was living there because in October, I think it was whenever she was talking about my son was there, October 2017 was when I found out she was there. But we discussed selling the home while she was there because I could no longer afford to make the mortgage payments, and she knew it was mortgage payments on the home.
So you believe that when she told the court that she didn't believe that there was a mortgage, she was not telling the truth?
She wasn't telling the truth. She knows that. I have documentation to that, and she has documentation to that. She took all of the paperwork out of the file cabinet on the home when she left, including the trust, which she claimed she had. So she knew.
Okay, all right. Thank you very much, Mr. Boone. No further questions, Your Honor.
I have no
All right,
other
anything else for this witness?
No further questions.
All right, do both sides rest and close?
Yes, Your Honor, I rest.
I rest as well.
All right, argument?
Your Honor, the burden is not on my client to show that proper service was done. The burden is on Mr. Boone. He was in contact with my client and never asked for her address. He could have gotten it from a variety of sources. There was no record made on the default judgment. There was no ad litem appointed, which under Texas Family Code 6.409 and Texas Rules of Civil Procedure 244 is a mandatory duty in order to grant a default judgment when citation by publication or posting on the courthouse door has been done, which it was in this case. My client was given letters saying that she could sign a waiver, but that doesn't give her notice. That's not proper notice anywhere in the code. She doesn't have to sign a waiver. She can elect to be served, and he didn't perform service. The affidavit from the process server, they're looking for the wrong person, and there was only one attempt done. So I think all this equates to that service was not properly executed, that the default judgment is void and should be a new trial should be ordered.
All right, Mr. O'Flynn?
Yes, Your Honor, thank you. Your Honor, with regard to the burden of proof, she's alleging a due process violation. And if you're going to allege a due process violation, then you must prove that there was no fault or negligence on your part.
Is that true? Is that true? Unless and until you show the respondent in the bill of review shows there's no error on the face of the record?
Your Honor, I'm going to quote Cnty Venture Limited versus Cremona Bistro Corporation, 469 Southwest 3rd, 160 at 164, Texas Supreme Court. It essentially says that you still have to prove, you still have a requirement, a burden of proving that you were not at all negligent in any of these, in failing to answer or failing to show up in court. And in her grounds for the bill of review, she's citing lack of proper service. Well, she was served on the courthouse steps. If there was something improper about that, no evidence has been brought up that that did not take place. She's also admitted that she had the petition, she knew about the petition, and chose not to act upon it. That's not something that my client's at fault for. My client has also testified that she secreted herself as to where she lived. She didn't want anybody to know where she lived. Well, I wouldn't say anybody. She didn't want her husband to know where she lived. And Mr. Boone has testified truthfully that his own children would not provide him the information because their mother would not want them to, and they would have to deal with the wrath of their mother if they provided their father any information on where she lived. Mr. Boone did what I call due diligence. He knew that she lived in Missouri, tried to have her served there. He did not know that she had moved from Missouri. She didn't tell him. He did not know that she moved to Cyprus. He found out eventually. His lawyer tracked her down there and sent her letters there. There was no response. She admits that she got the letters and didn't take any action whatsoever. And Mr. Boone has also testified that she didn't answer her telephone, maybe 40% of the time. And after the filing, wouldn't answer at all. So I don't know that my client did anything wrong. He certainly didn't have any, there was no extrinsic fraud in that he wasn't trying to defraud the court or her by having her served on the courthouse steps. He did what he had to do to try to find her, but she wasn't cooperative. She wasn't truthful about the mortgage. She had all the mortgage documents, yet I didn't think there was a mortgage. So I think Mr. Boone, and Judge, assuming that the trial court does grant a motion for new trial, you don't have to say there's an entire new trial. There can be a trial on the merits of just the property division alone, where the divorce can still stand. And the property division would be the only issue that should be before the court if indeed you grant the bill of review. Otherwise, I don't believe she's proved up no negligence on her part, Judge, because she knew about it and chose not to act.
Ms. Winnie, and on the, is there any reason why if a new trial is granted or the previous judgment set aside, it shouldn't be just for the property division?
Your Honor, since there wasn't effective service, I would think it would need to be on the whole findings of the divorce, but if the court is so inclined, just a property division, that is the only thing that is at issue here, really.
Can't have jurisdiction by consent. Have either of the parties attempted to remarry or anything?
I believe Mr. Boone is remarried.
All right. Mr. O'Finer, I believe the Texas Supreme Court has said on several occasions that everything you've recited about showing a meritorious defense and no lack of diligence on your part, that doesn't, you don't begin that inquiry until it's been established that there's no error on the face of the record. And I will find there is error on the face of the record. There was no ad litem appointed, and there's no statement of facts showing what facts the judge relied upon. And I will grant the motion for new trial. I will grant it only on the property division for the time being. I'll grant it only on the property division. I'll otherwise deny it. That may be iffy, but I don't want to undermine anyone's present marital status. So, Ms. Quinney, are you going to prepare an order on to that effect?
Yes, Your Honor.
Okay. And then I'll let y'all decide. Do we need a setting for the future, or do you need to do discovery, or?
I think we will need to do discovery, Your Honor.
Okay. All right. So if y'all want to get a docket control order in, that's good. Otherwise, just reset on request.
Judge, since the bill of review is granted, then we revert back to the original divorce petition. That's now going to be in play because the bill of review had its own cause of action.
Okay, so it'll be the 15 whatever.
Yes, Judge.
12/7/34. All right. I wish y'all good luck.
Thank you, Judge. Have a great day. Take care.
All right. Is Mr. Cavazos, Cedillos, have you and Amanda Torres had a chance to confer?
Yes, we have, Your Honor. We're gonna need a hearing.
Okay.
We've confirmed we are gonna need a hearing, Your Honor.
All right. Let me pull up my docket.
I'm trying to, Judge, I'm also trying to do the hearing with Judge
Ellison.
Well, we got a plea over there, but with this huge docket.
All right. And have we ever heard anything from Ms. Foyt?
No,
This
sir.
is Jim Cramp. She called me probably 25 minutes ago and said it'd be about a half hour and then she'd appear. So I'm expecting her almost at any time. And I believe my client, Bridget, can you confirm that you're on the phone? You're muted right now.
Yes, I'm here. Can you hear me?
Yes. How many, 2 T's or one?
It's one T.
Okay. All right, thank you. All right, Mrs. Cavazos, do you need a break before we start?
No, Judge.
Okay. All right, so let me grab the Torres case. And Mr. Cedillos, what do we have been hearing about?
Your Honor, this is a final hearing. We've been under temporary order since about October. So this is a final hearing on, it's a SAPSER.
Does your client have any criminal charges pending against him?
No.
And the arrest in McAllen, what became of that?
That's still pending.
I'm sorry?
That's still pending.
Okay, and what is the dispute over? Mr. Cedillos?
Well, my client wants to remain primary and keep the children here enrolled in Wilson County. And I know the agreement was 50-50.
Okay, hold on. Do you need a record?
Well, yes.
The court reporter just got knocked out. Her internet apparently is down or something.
Oh, okay. All right.
All right, I'm gonna go and work on trying to get my Acrobat set up so I can have all my stamps on it. I will ask the attorney, I'll ask you to let me know when she comes back.
Okay.
Hey.
Judge, just to let you know, Paula was having problems with corresponding on the chat. She can see the chat, but she's not able to use it. And I don't know what on our end we can do to help her get that function back.
I don't know if there's anything that happened yesterday and then it healed itself.
Okay.
And I have access to the breakout rooms right now. Yesterday I did not, I did Monday. I don't understand why that happens. I just put the one of Vinte's in the waiting room. I'm not sure why they're still hanging around. Sure. Well, Okay, Ms. Cavazos has signed in once. All right, Lachey, do you need to sign in twice or just one? You're only here once. You can't talk. Okay. Can you hear? I guess so. Obviously, you wouldn't be responding if you couldn't hear. All right, go ahead, Mr. Cedillo. Oh, wait, we'll wait.
Yes, Your Honor, just about 10
Hold
minutes.
on, hold on. Can you send me, you're good to go?
Not yet, Your Honor.
Okay. All right, you want to send me a chat message? I'm not sure what you're saying. I think you're saying you're not ready to go.
No, I'm not ready to go. I need
All right,
to clear.
I'm talking to Ms. Cavazos. Andy. All right, I just sent you a message in chat. Lachey, I'm looking here. And are you able to see my chat message? All right, so will you let me know in chat if you're ready for us to proceed?
Judge Wilson, were you talking to me?
No, I'm still talking to.
Okay.
Oh, and chat's disabled for her too. Okay. Okay, but was chat working earlier for folks? No? Okay,
It was working for me, but I don't know if anybody ever really ever responded to me on anything that I sent
well,
out.
but you're the host
Okay.
or a co-host. I'm the host or co-host. Mr. Cramp, does it work for you?
For myself, it just says chat disabled, and it's been like that the entire morning.
All right. We need to go back and check, and I'll do it to begin with. It may be that whenever we're setting these a few weeks ago, that somehow the disabled chat button got, you can disable chat when you set the meeting. That may have gotten inadvertently ticked. I don't know. Although I think yesterday people could chat for part of the day, and then they couldn't part of the day, then they could again at the end. It came back on, so God knows. All right. So Mr. Cedillos, go ahead, sir. Oh, wait, no, she's saying wait.
No, Richard Montoya has to wait. Next day is fine.
Judge,
Okay, Mr. Cedillos, I just muted you again. Ms. Cavazos, I believe, was signaling for us to wait. And she's still working on her other electronic device.
All right, Judge. Let's try
All
this
right,
again.
Mr. Cedillos, this time for real. Go ahead.
Michael Bear,
All right, Mr. Cedillos, go ahead, sir.
Yes. Your Honor, I'd like to call my first witness, Samuel Torres.
All right, well, let's get the parties sworn in.
Oh, okay, I'm sorry.
We ask Amanda and Samuel Torres to raise their right hands. Do each of you solemnly swear or affirm the testimony you may give in the matter now on trial will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Mr. Torres?
Yes, Your Honor.
Okay. All right, and Ms. Torres, Mr. Cedillos gave me a brief opening statement. What are you ready to proceed?
We can proceed. I mean, statement or,
Right, you're
I mean, I know
breaking up.
I don't have anybody.
You're breaking up. We can't hear you.
I don't have, can you hear me?
Yes, now we can. Okay.
Okay.
What is it that you're wanting to have happen today that Mr. Torres, that's different from what Mr. Torres wants to have happen?
Okay, since our last hearing, you had stated that as long as I have found, you gave me the chance to find a suitable place to live, and I did. And we were supposed to do 50-50, 1 week on with me and 1 week with him. Since then, he hasn't complied with that. I've just been getting them on the weekend visits. He's now asking for child support and wanting them full custody. I do not agree with that. I don't see a reason why the kids should be taken away from their mother completely. I thought that it was working out. I do still want 50-50. And we had agreed to no child support from either one of us. And he's trying to ask for that as well now.
All right, and Mr. Cedillos, do you have a copy of the photographs from the McAllen PD of Mrs. Torres?
No, I don't, Your Honor.
Have you seen them?
I haven't seen them.
All right, so do you have any idea how they wound up in the court's file here?
I have no idea.
They were submitted the last hearing.
I didn't get a copy of them.
When I was there in the.
Oh, okay, Ms. Torres, hold on. Okay, let me ask Ms. Kruger, do you know if these have been scanned in or?
830-393. I don't think they have, but let me just double check in our system here.
They're file stamped November 24th.
Okay, if they've been file stamped, then they're in net data. You said November 24th. Yes, pictures that were brought in by Amanda Torres. Oh no, I'm sorry, they're not scanned in. It's just mentioned that they were submitted and they're part of a court's record, but they're not scanned into our system.
All right, give me just a moment. I'm going to see if I can get the computer in the back to work. Otherwise, I'm going to ask the
if you would like, Judge, I can come and get them and I can scan them and send them to Mr. Cedillos if that's.
If you would, I'd appreciate it. It may be kind of voluminous to post over chat in Zoom.
Okay.
We're going to be in recess just for a few minutes for that to happen. Mr. Cedillos, I just want you to look at these, and I don't know if they really are McAllen PD photographs. I don't know that your client has any connection with what appears to be significant injuries on Mrs. Torres, but I want you to have a chance to look at these and discuss them with Mr. Torres and whether he wants to proceed today testifying. And so let's make sure we're all on the same page.
Okay, all right, thank you, Your Honor. I'm gonna go talk to him. He's in our conference.
And if you'll just let me know when you had a chance to review those, Mr. Cedillos.
Okay. They're being
I don't
sent in,
expect I don't expect they've been sent yet. I'm working on something else. I can't see everything right. I can't see. I only have one monitor, so I won't be able to see what's going on. Just let me know when I need to come back.
okay, Your Honor.
Judge, I'm having a little problem with scanning the documents and sending them, so I don't know if it's my computer.
I'm sorry, I muted you by mistake, Ms. Kruger.
I'm having one of the other clerks try to scan those pictures and send them to Mr. Cedillos. I'm having a problem with my computer.
Okay.
Judge,
Yes, ma'am.
I don't know what's going on over here. I'm gonna be off and on. So,
Okay, well, we'll hold on. We're waiting for Mr. Cedillos to have a chance to review some documents.
yeah, it's just super windy. So I don't know if that has anything to do with it.
It might, I don't know.
I
I've had some weird stuff going on where everybody's video feed goes away except whoever's talking. They don't have their video off. I just can't see them. So, although they're working right now. All right, we'll just wait for Mr. Cedillos.
Okay.
Mr. Cedillos?
Yes.
Okay, so you should be getting an email from Michelle. It's going to come in several emails. We're having an issue getting the pictures attached to an email.
Okay.
Well, it's doing this with your
Judge Lisa Voigt came in.
Yes.
I don't know if she needs to be in a breakout room with Mr. Cramp or not.
Catherine, I needed to talk to him.
Armando Valdez.
Okay, and Mr. Cramp, are you available? Well, I've asked him to unmute and I've asked him to start his video. Mr. Cramp? All right, Ms. Voigt, can you hear us?
Yes, sir.
Okay. All right, well, he's been here. I'll ask you to just hold on for a bit. We'll see what happens. I hear it now. All right, Ms.
You want me to-
Redfern, are
You want me to try
you,
calling his office, Judge?
please?
Yes, Judge, I'm here.
All right, thank you. All right, Mr. Cramp apparently stepped away from his computer. We'll wait on that.
He's back, Judge.
All right, Mr. Cramp.
Yes, sir. I tried to sneak in a quick bathroom break and I knew that's when Lisa would show up.
All right, do you need a breakout room, or are you ready to proceed, or?
No, I'm ready to proceed.
All right, Ms. Floyd, are you ready to go?
Yes, sir.
All right, go ahead, sir.
Your Honor, this is an effort to clarify the division of property in the parties' decree of divorce, which was rendered by this court on November 25th of 2019. In the decree, it bungled by combining together a division of the respondents' federal employee retirement system annuity and thrift savings plan, both of which my client was awarded 100% in the decree. She submitted the decree to the Office of Personnel Management, which administers the federal employee retirement system annuity, and they declined it, requiring clarification. Same thing with the thrift savings plan. So I have drafted clarifying orders. I do a lot of FERS work and a lot of TSP work. So I've drafted the clarifying orders. And then my client was also awarded some bank accounts at Randolph Brooks, and Randolph Brooks declined to provide my client access to the funds simply based upon the decree. So I've drafted a separate order for the court to reduce her award to a money judgment. And as I shared with you, then I will follow up with an application for a writ of garnishment. If you want to hear any testimony from my client on what I just told you, that all of these efforts were turned down, requiring either clarification or another method of resolution, such as a reduction to a money judgment and writ of garnishment, I'll be happy to have that. But you know, as I shared with my client, this is mostly a legal argument between the attorneys.
All right, I guess what I'll ask is, Ms. Voigt, do you have an opinion as to whether this whatever proposed order Mr. Cramp has, is that just a clarification, or is it actually changing any substantive order?
No, I did not see it change any of the orders that were originally rendered. It's just dealing with different agencies and what they require in order to follow through with the judge's order.
Okay.
Yeah, and if I can, sir, I've actually produced 3 orders, and I did that because two of them need to go to the separate entities. What I will call my lead order is the motion to enforce, or pardon me, the order on motion to enforce the division of property in the final decree. And that it is giving my client a judgment for $32,715.16 plus $3,080 in attorney's fees for a total judgment of $35,795.16. That's the judgment based on the Randolph Brooks accounts. And I did subpoena business records. I did serve them on Attorney Voigt back in January. And yesterday I e-filed them with the court, but we do have the business records to verify those balances. And then I have a separate, my second order is an order clarifying the property division. And then in that second order, I clarify both the Federal Employee Retirement System Award and the TSP award. And then I set forth a proper order dividing the Federal Employee Retirement System benefits. And because that order will have to go to the Office of Personnel Management. Then my third order is an order clarifying the division of property and an order on the Civilian Thrift Savings Plan account, because this order only needs to go to TSP. You know, I didn't want to. I
understand you don't want to clutter up
exactly
going to each place with extraneous matters.
Exactly, it'd be too confusing.
All right, and have someone prepared a statement of evidence?
I can prepare a statement of evidence. I looked in the family code yesterday, and it said, I think it's in 6.409, and it talks about that with regards to a divorce. I didn't know if I didn't interpret it that it would be necessary today, but I can certainly submit one.
I think it would be better.
I
don't know if you listened to the first hearing I had this morning.
I guess
Okay.
I don't recall.
Okay, it was all about 6.409 and how somebody took a default, and in that case, they did not appoint an ad litem or have a statement of the record. And there's case law. It's not from San Antonio, but there's case law that says at least when you fail to do both of them, which they did, that's just automatically reversible. You don't, on the bill of review, you don't even reach the no negligence and defense arguments. It's void. So
that's fine. As soon as we're done here today, I will prepare and e-file a statement of evidence.
Okay, I'm gonna give Ms. Wood a chance to sign off on it. And
well, she can speak for herself, but she hasn't signed any of the orders. She was the attorney ad litem on the decree as well. And she told me she wasn't comfortable signing the orders because she hasn't been able to establish contact with Mr. Redfern.
Okay. All right.
But I will send it to her.
All right, and I guess, Ms. White, I guess here's what I would ask is on the statement of evidence, it just if you would sign either that you agree with it or that you have no objections to it. And I'm not asking you to sort of like what happens with the all the tax cases where we have ad litems.
Mm-hmm. Just the format itself is I agree with.
The format itself you agree with, and that you're not objecting to, I guess, the proof that's been put on. You're not. I haven't read one of those in a while. I've read them, but basically just that. Okay. Just look at it, and also if you would just file something that says whatever efforts you've made to contact the.
I did file a report, Your Honor, this morning.
Oh, you did? Okay, excellent. It was not. I didn't see it in the file when I looked earlier, but okay, excellent.
No, I have received her report and read it, so it looks good to me.
Okay, excellent. All right, this doesn't have to be anything elaborate. Just so there's something there for the findings, and if you will either e-file or post all of that in chat when I have all those together, I will sign them.
Very good, sir. Chat is disabled for me, so I'm not sure I can.
I'm sorry. We're going to explore that. I'm sorry.
I will e-file it with the district clerk.
All right,
And
please do so.
I will. Sir, if I can ask you a question about the writ of garnishment. The defendant, Michael Redfern, is not a necessary party. The Randolph Brooks is going to be the garnishee, but I do have to serve, as the court knows quite well, I do have to serve the defendant, and can do so if the court allows me, not by citation, but under Rule 21A. I mean, I can send the required documents by certified mail return receipt requested to his last known address, which would be legal notice, but not likely to result in actual notice. I discussed with Attorney Boyd. I don't know if the court, because the defendant is not a necessary party, if the court would want me to have an attorney ad litem for the writ of garnishment action.
I've never done that. And is this guy just falling off the face of the earth, or it just?
Well, Bridget,
Bridget,
could you please give the judge some background on your case?
Sure, Jim. Can everyone hear me?
Yeah, you want to swear her in first, Judge?
Certainly.
Okay.
All right. You solemnly swear or affirm the testimony you may give in the matter now on trial will be the truth, the whole truth, and nothing but the truth. So help you God.
Yes, I do.
All right. Go ahead, sir.
All right, Bridget, please give the judge a brief background to the factors that led to the divorce and why you don't know where Michael is as of this date.
So in May of 2019, Michael was detained by Tinker Air Force Base security forces and interviewed by OSI. So it's a special investigations group, and he was in possession of child pornography. Those children in those photos were my children, and he had taken those in our home here in Texas. At a later date, I actually found additional photos in my garage, and I turned those over to Wilson County Police. And most recently, he was indicted on 8 felony counts in Wilson County in March. I do not believe he will ever return, and I think he's fled the country. So nobody's heard anything from him. I do still keep in contact with some of his siblings, and they have not seen or heard from him either. So would you like additional detail or information?
No, that's fine. And he's retired military, or?
He's retired federal civil service.
Retired civil service. Okay. All right. I would expect it. No, they're going to catch him sooner or later, but he's got bigger fish to fry. All right, then I will sign those whenever I receive them.
All right, thank you, Your Honor, and I will get that statement of evidence submitted.
Okay, all right. Thank you, sir.
All right, thank you. May we be excused?
And I guess I didn't answer your question.
Well, please.
Yes, just serve him at whatever address you have as his last known address, and if and when he shows up, if he wants to show up and complain about it later, I'm sure the sheriff's office will be glad to see him.
All right, thank you, sir. And if I can, Lisa, do you want to tell the court about your fees?
My efforts, it's basically the same thing that Ms. Redfern said. I've checked, I've had telephone contact with law enforcement. They say the same thing, that he disappeared back in May of 19. They've checked hospitals. They've checked up in Oklahoma. They checked with their jails. He was not in custody anywhere. I've checked recently with Texas to see if he was in custody anywhere or in TDC, and that was the answer was no. I've checked obituary records, and there was no finding on Facebook, LinkedIn, social media groups he used before. Those have not had any activity. That's pretty much the extent of it. Family said the same thing.
So, sir, I will incorporate by reference the ad litem's affidavit within the statement of evidence.
Okay. Sounds good.
All right, thank you, sir. Unless you have anything else for us, may we be excused?
Yes, go ahead.
Thank you, sir.
All right, and Mr. Cedillos, have you received the emails from the clerk's office?
Whatever county she filed.
You had 432 days to get your breach on that was taken care of.
Hello?
Yes, have you received the emails from the clerk's office?
We got the pictures. We got the pictures, Your Honor. They were hand delivered.
Oh, okay, all right. Have you had a chance to go over them with your client?
Pardon?
Have you had a chance to review them with your client?
No, I've been standing by. He's in a different conference. He's in a conference room. I've been standing by with Judge Ellison.
Okay.
Let me go.
All right, that's fine. Take your time. Just let us know when. I've got plenty to work on here. Let us know when you've had a chance to review them with your client.
Oh.
Oh, and I'm sorry, I muted you. I meant to mute myself. let's see. Mr. Torres, I'm asking you to unmute.
Yes, sir.
Are you still there with Mr. Cedillos, or?
Yes, sir. He's in the other office, sir.
Okay, because he disappeared from the Zoom meeting.
The Zoom. Yeah, let me get a hold of him real quick. They're getting a hold of him right now, sir.
All right.
I'm so
just
sorry.
Get him to log back in. Thanks.
Yes, Your Honor. He got kicked out. He's trying to log in, back on. Trying to log back in.
Okay, leave and join. Let's try again. I don't know what it's doing. Do that.
Your Honor, I'm present.
Thank you. Are you still conferring, or I know Judge Ellison broke for lunch?
No, we're gonna go back at 1:15.
Right. So have you had a
We're
chance to
ready.
speak to your client?
Yes, I have, Your Honor.
Okay. All right. And are we going ahead with the hearing today?
Yes.
All right. So are both sides ready?
Yes.
Petition's ready, Your Honor. You want to keep trying?
Yeah. Do you want to?
Ms. Torres, are you ready to proceed?
Yes, sir, I am.
All right. Go ahead, Mr. Cedillos.
I'm going to call my first witness, Your Honor, Samuel Torres.
Go ahead.
Mr. Torres, would you say your name?
Yes, Samuel Torres.
And where do you live, sir?
We're here in Floresville.
What's your address?
246 County Road.
And you?
168.
Okay. And what are the names of your children?
Silas, Corbin, and Aiden.
And you have 3 children, right?
Yes.
How old are they?
7, 10, and 12.
Okay. You have been under temporary orders with your Amanda Torres.
Yes.
Since when, sir?
Since I got him October. It's
Okay.
October.
And you were supposed to you and her agreed to have a 50-50 split custody. Is that correct?
That is correct, sir.
But tell the court why that didn't work out.
She asked me one time, but other than that, she didn't try to pursue it or anything like that.
Okay,
And
make sure you
pretty
tell who she is. Tell the court who she is.
Anna didn't pursue it.
Okay. Your Honor, I'm going to try to I was having trouble logging into my computer, and I'm gonna get out of my my iPhone.
Go ahead.
Can you hear me?
I'm sorry? I'm not able to hear you, Mr. Cedios.
Can you hear me?
Yes, barely.
I'm having trouble. I'm gonna go join my client in the conference room.
Go ahead.
Okay. Can the court hear me? Is it what you're hearing?
Yes, go ahead.
Hello?
Yes, go
Okay.
ahead, sir.
So Samuel, did you try to exercise 50-50?
Yes, I did.
And there was some stipulations with a 50-50, is that correct?
Yes, she was trying to find somewhere to live.
And did she find any place to live during that time?
Yeah, she did. She found like off-campus living dorm.
And what's wrong with that off-campus living dorm?
I guess there's like 4 rooms. That's what the kids were telling me, like 4 rooms where I guess they rented out to other people, like general living.
Okay, so she was sharing rooms with other people.
That is correct.
But you didn't decide on your own not to exercise a 50-50, is that correct?
That is correct.
She only asked for them one time 50-50.
The one time on the phone, yes, sir.
Okay. Is that a concern with you with regard to the best interest of the children and their welfare?
Yes, sir, it is.
Why is that?
It's just what she has a 1-bedroom apartment. I mean, they sleep on the floor and the couch, and I know she has a boyfriend. So for men, I think it's kind of hard for the boys.
Okay. How are the boys doing in school?
They're doing good.
Do you know their grades?
Yeah, Jacob went to C from a G.
What is G meaning good?
Yes.
Okay. And how about the other boys?
They're doing good too as well.
Okay. Did Amanda in the past go spend the night at your house?
Yes, she did twice.
And when was this?
In the beginning.
You got to tell the judge in the beginning when.
It was around like October.
Okay. And has she ever gone to ride you drive a motorcycle, is that correct?
That is correct.
And she's also gone to ride a motorcycle with you?
Yes, she has.
So she's not fearful of you?
No, sir.
Okay. Okay. You, Amanda picks up the children how often?
Thursdays, and then she drops them off at school. Monday morning, then I end up picking them up.
Okay, and
Yeah,
go ahead.
yeah, every first and third of the week, and 5 of the week, the 5th of the week.
5th of the, okay. Did you have them? Did you have them during spring break, or did she?
I did, sir.
Okay. How about during Christmas break? Who had them?
She did.
Okay. So the visitation's been able to, you have been working, the visitation has been working out as far as she gets them on the 1st, 3rd, and 5th.
Yes, sir.
And she hasn't complained to you before.
No.
She only wanted them that one long week, that the whole 50-50 once before today. Is that correct?
That's correct.
Okay. When Ms. Torres has the children, and you're not married, right? You just both share the same name.
That's correct, sir.
Okay. When Ms. Torres has the children on her weekends, are the children getting to work? I mean, I'm sorry. Are the children getting to school late?
Yeah, yes, they get tardy.
How many times in January were they tardy?
January, they're signed out early. Oh, 1, 2, 3, 4, 5. No, that's one. On January was one time.
Okay, but as far as being tardy, were they tardy more than one time in January?
Yes, they got signed out early too as well.
Okay, and were they tardy in February?
Yes, February was 1, 2, 3, 4 times.
And how about March? Have they been tardy in March?
No.
Okay, in April?
Yes, the absent just on Friday recently.
Okay, but this is when they were basically under Amanda Torres's watch.
Mr. Cedillos, hold on.
Okay.
Amanda Torres has gone blank. Are you still there, ma'am? I'm asking you to unmute. Can't hear you. And there she goes. All right, let's give her time to check back in.
Okay. Do I proceed, John?
Can you hear
All right, Ms. Torres, can you hear me?
me? Yes, all right.
All right. What's going on with your video? I'm asking you to start your video.
It is on, sir. It's on. It keeps kicking me out every now and then, and it keeps connecting, but I am the video and my sound is on.
And what sort of device did you sign in on?
It's my phone.
Right. Okay, now I'm not crazy. She disappeared there for a minute and now she's back. I mean, maybe crazy, but there were only 6 boxes for a while. Right, I'm asking you to unmute, Ms. Torres.
I'm unmuted.
Okay. Is there anywhere you can go where you'll have better reception on your phone or more bars or something like that?
I have all my bars. It just, once we started the hearing, it started kicking, like the whole time that we waited for him to read his papers and discuss.
All right, man, this is not going to work because, Ms. Torres, this is not going to work because your your audio keeps breaking up and we can't hear all of what you're saying. So what can you do? I understand apparently the internet is behaving. All right, Ms. Torres.
Can you?
Can you hear me? All right, can you hear me, ma'am? All right, Ms. Torres, you need to leave the meeting and then sign back on. Let's see if that helps.
Okay, leave meeting and sign back on. Okay.
Yes.
All right, can you hear me?
All right, can you hear me now?
Yes.
All right, that's better. Go ahead, Mr. Cedillos.
Mr. Torres, would you describe the living conditions of your house?
Yes, sir. I got a 5-bedroom apartment, five bedroom house, and a three bathroom. It's over 2,000 square feet. I mean, the boys have their own room. Sir.
Okay, and you're living with someone else right now, is that correct?
That is correct, sir.
And who is that?
That's Annette Mendoza.
Okay, and she helps you with the children also?
That is correct.
Okay, and would you also, we talked about the days that they were either absent or they got tardy. Why were the boys absent on April the 16th?
I called Aiden. Aiden told me that he was already ready to go, but the mom was still asleep. And I said, well, wake her up. I was like, well, she doesn't want to get up. So it's like, so pretty much that's what it was.
So they missed school that day?
That is correct.
Okay. Mr. Torres, today, what are you asking the court to do? You want to be named primary custodian of the children?
Yes, sir.
Okay. How long did you live with Amanda Torres?
Well, we worked together for 12 years.
Okay. And you lived in the Rio Grande Valley in McAllen, right?
That is correct, sir.
Okay. Today you're asking this court for child support because the 50-50 doesn't work?
No, sir, it doesn't work.
Do you know how much Amanda makes?
Well, last time she told me she makes up to $1,000 to $2,000 a week.
Okay. Do you believe it's in best interest of the children to come live with you here in Wilson County?
Yes, sir.
And why is that, sir?
Pretty much, it's better off. It's stable condition of living, and they have their own rooms. There's pretty much.
How do the boys? Can you describe the boys' demeanor when they come back from visitation with their mother?
Well, the two oldest, Aiden and Silas, are really good actually. But my littlest one, Corbin, my 7-year-old, he comes back. Every time he comes back, he's always coming back with the attitude and slamming doors and stuff like that and yelling and cussing. It takes like 2 days to get him back to where he needs to be, like being, he doesn't have to yell and stuff like that.
And your oldest one has expressed a desire to remain with you. Is that correct?
That is correct, sir.
In fact, has your middle boy said that too?
Yes, he has.
But he's only 10.
Yes, he's only 10, sir.
Okay. I'll pass the witness, Your Honor.
All right, Ms. Torres, this is not a chance for you to testify. You will have a chance to testify later. This is, however, a chance for you to ask questions of this witness. What questions do you have for this witness?
Well,
All right, Ms. Torres, you continue to disappear and then come back. I mean, I know it's not something you're doing, but that we can't proceed with the hearing like that.
I don't know what else to do. I have all fours. I don't know what's going on and why it keeps doing that. Like I said, it just started doing that.
Okay.
The only
What city are you in?
I'm in San Antonio.
Okay, and do you have a laptop,
I do not, sir.
a tablet?
No, sir.
Give me just a moment.
Okay.
All right, Mr. Cedillos, what court do you have tomorrow?
I have an entry of judgment tomorrow.
All right, would you be available at 10 or 10:30?
I could make myself available, Your Honor.
All right, Ms. Torres, can you hear me?
I think he's gonna recess. Really?
All right, Ms. Torres, can you hear me?
Yes, sir.
All right, I just barely heard you. I think that may have been a yes.
Yes, sir.
Okay. I don't know if you'd get a better telephone reception somewhere else. Would you be available at, say, 10 o'clock, 10:30 tomorrow morning to be in court in person in Floresville?
Hear you, Your Honor.
I can't hear you.
I didn't hear you. The video froze.
Okay, well, all right. Would you be available to be in Floresville for court at 10:30 tomorrow morning?
I can, yes.
Okay. And will Mr. Torres be available, Mr. Cedillos?
Maybe we'll. That's fine. Yeah, you want us live, Your Honor?
Y'all are welcome to be here live if you like. We're about to start up anyway.
Okay.
But yes, I mean, Ms. Torres, if you're certain you have some better solution for accessing the internet, that's great. But we're not able to proceed right now.
I can be there tomorrow morning at 10 a.m.
Okay, well, make it 10:30.
Okay, 10:30.
Okay, and you know where the courtroom is?
Yes, sir.
Okay, all right, we'll see you at 10:30.
Thank you, Your Honor. You have a good day.
Thank you, Your Honor.
Mr. Cedillos, you can either sign on live or you can be here in person, whichever.
Okay. All right. Thank you, Your Honor.
I'll send out the links just to be on the safe side.
Thank you.
Thank you.
Thank
All
you.
right, just let me go back and look.
Thank you.
I don't know what it is. Everything.
Okay, so Redfern, it's orders to be filed. Mazick, reset on request. Torres, 422. Rashid and Bone, order to be filed. Bonavente, reset on request. Smith, 622 entry.
Correct. That's what I have, Judge.
Okay.
All right.
And you know what's truly scary is that I haven't moved. Now I can see almost half of my face, and I haven't moved and the computer hasn't moved, but
I can see
now
all of
see
you.
more of my face. So I don't know how much of, are you all seeing all of my face?
I see all of you. Yes. But the Amanda Torres was coming in and out. It was.
Oh, yeah,
so,
yeah, no.
I don't know what was going on with that.
And I've never seen it, maybe a one blip, but she disappeared half a dozen times and then came back, and that without ever, I mean, usually without being admitted through the waiting room. So I don't know what the hell that is. So y'all can see all of me. Okay, so y'all can see me eating my protein bar. Well, I'm gonna have to mute my damn screen.
And your Topo Chico.
Okay, and now I'm sitting right here. This is just bizarre. Now I can only see half of my eye on the, I guess, right-hand side with the American flag. I could see all the way to the edge of my nose, and now I can't even see half the eye. That is just
That's crazy. And you have your, I thought your hand was up, but no, that's me.
no. I have not. I have not moved to
Wow.
a millimeter, or has my computer. All right.
No.
I will see y'all tomorrow.
All right, Judge. Take care. Bye, Lachey.